The notion of law and order has served as a cornerstone of organized societies throughout history. Laws, the codified set of rules governing behavior, and the broader concept of order, the social harmony resulting from adherence to these laws, are foundational elements of any society. They operate on the tacit assumption of human agency and choice, the idea that individuals are free to make decisions and are therefore accountable for their actions. This is where the concept of free will is intrinsically embedded in our legal systems. Free will is the ability to make choices that are genuinely one's own and not the outcome of causal chains of events that trace back to the dawn of time. In this context, law serves to guide these choices along paths that society deems acceptable, establishing norms of behavior that serve to protect individual rights and maintain social harmony. The assumption of free will is critical in this equation because it underpins the idea of responsibility. If individuals were not free to make choices, it would be fundamentally unfair, not to mention impractical, to hold them accountable for their actions. However, it is crucial to note that this relationship between law and free will is not explicit. There is no statute or legal document explicitly stating that the legal system operates under the assumption of free will. Rather, it's an implicit principle woven into the very fabric of law and order. It can be seen in the way we approach guilt and innocence, in the method we assign responsibility, and even in the way society reacts to the pronouncement of judgments. If we consider the law as a means of deterring unwanted behavior, the implicit role of free will becomes even more evident. Deterrence operates on the assumption that individuals have a choice in their actions. When faced with a potential decision to commit a crime, the fear of legal repercussions is supposed to serve as a deterrent, discouraging that choice. In other words, laws are designed to nudge our free will in the right direction. Take, for example, the law against theft. The premise is simple: if you steal, you will face legal consequences, which might include a fine, imprisonment, or both. This law, like any other, is intended to deter potential thieves by presenting a clear consequence for their actions. The key factor here is the presentation of a choice. The potential thief can choose to steal and face the punishment, or choose not to steal and avoid the consequences. This simple scenario is a perfect illustration of how free will is implicitly woven into the fabric of our legal system. It's worth noting, however, that this paradigm of law and order may seem overly simplistic in the face of real-world complexities. Human behavior is rarely motivated by a single factor, and choices are not always as clear-cut as our theoretical example. The socioeconomic status, education, upbringing, and countless other factors play a role in shaping our decisions, often blurring the lines between free will and determinism. One could argue that laws serve not just as a deterrent for antisocial behaviors, but also as a moral compass, guiding individuals towards right actions and away from wrong ones. This moral aspect of the law underscores the implicit role of free will even further. Consider the laws concerning human rights, such as those prohibiting discrimination or hate speech. These laws do more than just punish transgressions, they make a moral statement about the values that our society holds dear, values such as equality, respect, and dignity for all. By adhering to these laws, individuals are not just avoiding punishment, they are aligning their actions with the moral values upheld by the law. The role of free will becomes evident here as individuals freely choose to act in alignment with these values, influenced not just by the fear of legal repercussions, but also by their moral compass. In essence, the law is believed to provide an environment where people can exercise their free will to make morally right decisions. Yet, this brings us to another dimension of the law-free will conundrum. What if an individual's moral compass doesn't align with the law? What happens when the exercise of free will leads to actions that, while legally sound, are morally questionable? Such instances underscore the delicate balance between free will, morality, and the law, a balance that often treads on a tightrope. One of the most profound areas where the concept of free will subtly resides within the legal system is in the world of punishment and rehabilitation. How a society decides to punish its wrongdoers or work towards their rehabilitation is intimately tied to its belief in free will. If we assume free will, it becomes reasonable to administer punitive measures as a response to criminal actions. The belief here is that individuals, having freely chosen their actions and having been aware of the laws they were breaking, should face consequences. This perspective aligns with retributive justice theories that see punishment as a deserved consequence of wrongdoing. On the contrary, rehabilitation takes a different view. Here, the goal isn't to simply punish the wrongdoer but to change their behavior and reintegrate them into society. This approach often goes hand in hand with the acknowledgement that external factors beyond an individual's control can influence their actions, somewhat challenging the concept of free will. In essence, whether our legal systems lean towards punishment or rehabilitation might reflect our collective belief, or disbelief, in free will. A legal system rooted in retribution might imply a stronger belief in free will, while a rehabilitative system might suggest recognition of determinism. The concept of free will doesn't just manifest in lawmaking or court rulings, but also significantly shapes the creation and application of legal precedents. A precedent, a legal case that establishes a rule or principle that courts follow when deciding later cases with similar issues or facts, heavily leans on the assumption of free will. Precedents hinge on the belief that individuals, given the same set of circumstances, have the free will to choose similarly. That's why, for instance, if a court decides that under particular facts it is a violation of equal protection to award damages on the basis of race, future courts will follow that decision. The underlying assumption is that individuals, fully aware of the potential consequences of their actions, such as a violation of equal protection, would refrain from such behavior. It suggests that individuals could have chosen differently under the same circumstances, reinforcing the idea of free will. But what if this isn't the case? What if determinism holds, and our actions, even in similar situations, are the result of our unique genetic makeup and life experiences? That would challenge the very basis of legal precedents, making room for the argument that every case is unique, given the unique deterministic paths of each person involved. Once we recognize the deep-seated role of the assumption of free will in our legal system, it forces us to ask the difficult questions: what if our understanding of free will is flawed? What if deterministic forces have more say in our actions than we give them credit for? In the face of such inquiries, the legal system may have to reorient its understanding of responsibility, guilt, and punishment. If deterministic factors significantly influence our behavior, then our legal paradigm based on the idea of individuals acting differently under the same circumstances may need to be reassessed. Such a reformulation doesn't necessarily mean a disintegration of our current legal system, but it would certainly call for a more nuanced understanding of human behavior. This could potentially involve greater emphasis on rehabilitative justice, considering the deterministic influences on behavior.